Welcome to the Luxembourg Funcast.
Great to be here.
Today we're doing a deep dive into something quite specific, but really fundamental in Luxembourg finance: capacity legal opinions.
Absolutely crucial, especially if you're working in law, finance services, corporate governance, or compliance here.
Right. So why are they so vital in Luxembourg's, let's say, complex financial world?
Well, they provide essential assurance, really. Confirmation that your counterparty actually has the legal power to do the deal.
Okay. So today we're going to try and unpack the why, the rationale, the who gives and gets them, the what's actually in them.
And the how. So the legal basis, the documents needed, practical stuff like negotiation, costs, timelines.
And we'll also touch on recent legal updates, how things are evolving, because there's this increasing demand for formal legal certainty, isn't there? Risk mitigation is key.
Definitely. So let's start with the why. At its heart, a capacity opinion is about assurance. It tells the recipient, maybe a lender, an investor, that their partner, contractually speaking, has the legal muscle to enter the deal and do what they promise.
And if they don't?
Big problems. The whole transaction could be void, unenforceable. Think financial loss, legal headaches. It's rooted in basic Luxembourg contract law and corporate representation principles.
Makes sense. It's not just a piece of paper then.
Not at all. Especially in cross-border deals. A Luxembourg opinion clarifies things for foreign parties dealing with a local company. It bridges that understanding gap.
So it's that formal check, can they legally commit? Because if not, the deal could just collapse.
Exactly. It avoids that nightmare scenario.
Yeah.
So that's the why. Now, who are the players? The who.
Right. Who issues these things?
Typically, it's Luxembourg qualified lawyers or law firms. Often it's the lawyer for the entity whose capacity is being checked, say, the borrower's counsel.
But not always.
No. Sometimes the recipient's lawyers might issue it, or at least review it very, very carefully. Depends on the negotiation dynamics.
Ah, okay. A bit of back and forth, potentially.
Can be. And the recipients, they're the ones carrying the risk if capacity is missing. Lenders, agents, security trustees, investors, anyone relying on the counterparty being legally bound.
And regulators are interested too, right? You mentioned CSSF circulars.
Yes, increasingly.
Yeah.
CSSF Circular 19719 on STS securitizations, for instance, says opinions should be available to third parties and authorities.
Okay.
And Circular 25890, which deals with MiCAR, the crypto asset regulation, also refers to legal opinions needed in certain situations. It shows regulators value this legal clarity.
So the lawyers doing this need serious expertise, especially with new areas like MiCAR or, say, DORA for digital resilience.
Absolutely. You see more specialization in Luxembourg's legal field because of this complexity. Assessing capacity for new crypto assets under MiCAR or ensuring DORA compliance in tech contracts, it requires specific knowledge beyond just general corporate law.
Okay, so we've got the why and the who. Let's dig into the what. What exactly does a capacity opinion confirm? What's its core purpose?
Its core purpose is to confirm key legal points about an entity's ability to validly join a specific transaction. And that's key. It's tailored.
So not just they're a legit company statement.
No, much more specific than a simple good standing check. It typically covers several points. First, do incorporation and existence, was the company properly formed under Luxembourg law, and does it legally exist?
Okay, what else?
Second, corporate power or capacity.
Wow.
Does the company have the necessary power to enter into this specific deal and perform its obligations? This involves looking at the corporate object, the object social, to make sure the deal isn't ultra-vires, beyond its stated powers.
Got it. And authorizations.
Yes. Third point, do authorization. Have the correct corporate steps been taken? Think board resolutions, maybe shareholder approvals.
Well, execute.
Yeah, it's number 4. Do execution. Were the documents properly signed by people who actually had the authority to sign for the company?
Right.
And finally, often the trickiest bit, enforceability. A statement that the company's obligations are legal, valid, binding, and enforceable. Though this almost always comes with significant qualifications.
I can imagine. And does this change with new things like crypto?
It evolves, like that CSSF circular on shows opinions might now need to address the qualification of the crypto asset itself, so the scope can broaden. And you also see related capacity issues pop up in court cases about, say, the capacity to sue or be sued, capacité de stare en justice. It all ties back to legal standing.
Very thorough. Okay, let's anchor this in the law itself. What's the legal bedrock here in Luxembourg?
The foundation is really the Luxembourg Civil Code for the general rules on contracts and legal capacity.
Basics.
Exactly. But applying those basics to complex companies means you really have to dive into the corporate laws and how courts interpret them.
So any specific articles from the Civil Code that are fundamental?
Well, historically, Article 1108 set out the conditions for a valid contract. Consent, capacity, a specific object, a lawful cause. Always best to check the current text on Legilux, of course, for precision.
Natural.
Then Article 1123, again, check Legilux for the current version, essentially says any one person or company can contract unless the law says they can't.
Are there specific incapables mentioned?
Article 1124, as amended back in '82, mentions unemancipated minors and protected adults with capacity limited as defined by law. And interestingly, Article 1125 says capable folks can't use the other party's incapacity to wriggle out of their own obligations.
Oh, okay.
Plus, there are many other articles on status and capacity. And don't forget Article 6 on public policy and good morals, or the public bon mir. That sets a general limit on what contracts can do, sort of relevant to the lawful cause idea.
Right, so that's the Civil Code framework. How does the specific company law, the law of 1915, fit in?
The law of 1915, as amended many times, is key for commercial companies like SAs and SARS. It governs how they're formed, how they run, and critically, their capacity.
Okay.
A core principle is that once properly set up, they have their own legal personality, separate from shareholders. They can act in their own name.
And they act through their directors and managers.
Precisely. Article 116 says companies act via their appointed organs, directors, managers. Their powers come from the law, the Articles of Association, the statutes, and other company decisions. The statutes are crucial here for defining powers and representation.
And the objet social, the company's purpose. You mentioned ultravires. How important is that now?
Historically, acting beyond the objet social could void the act. But modern Luxembourg law, following EU directives, really protects third parties acting in good faith.
So less risk for outsiders?
Generally, yes. Article 113.4 says the company is usually bound even by acts outside its object unless the third party knew or couldn't have been unaware it was ultravires. Just publishing the statutes in the RCS isn't enough proof they knew.
But lawyers still check the objet social.
Oh, absolutely. For good corporate governance advice, directors approving ultravires acts could face internal trouble from shareholders, even if the external deal holds. Plus, Article 117 protects third parties if there were irregularities in appointing directors, provided publicity rules were met and the third party didn't know. So it's this mix of civil code principles and the law of 1915, especially around organ powers and third-party protection, that underpins the capacity opinion analysis.
Okay, that paints a clear picture of the legal framework. Let's get practical now. Crafting the opinion, what documents are needed, and what's the verification process like, the how and where?
Right. This is where the meticulous work comes in. It involves careful document review and verification. And a key resource here is the Luxembourg Trade and Companies Register, the RCS, managed by Luxembourg Business Registers, or LBR.
The RCS, that's the starting point.
Definitely a central piece. You absolutely need the constitutional documents, especially the latest coordinated articles of association, the statutes coordinate. They set out the company's purpose, representation rules, how decisions are made. They're filed with the RCS.
And from the RCS itself.
A recent RCS extract, the X-Rate RCS, is vital. It gives you a current snapshot. Legal status, address, directors, managers, their powers, confirmation of no insolvency. But remember, it reflects what's filed at that moment.
So you need more than just the extract.
Yes. You also review other RCS filings. Acts appointing or removing directors, managers, auditors, maybe resolutions filed, annual accounts, notices of amendments. Article 13 of the RCS law lists everything that should be filed in public. There's even a ministerial regulation from 2016 on the technical filing criteria.
And this filed information is reliable?
Generally, yes. Article 19.3 of the RCS law, linked to the company law, makes legally required publications opposable to third parties shortly after publication. So people can generally rely on what's officially published via RCS and RESA, the electronic platform.
Okay. What about documents specific to the deal itself?
Crucial. You need certified copies of board or manager resolutions, maybe shareholder resolutions too, specifically authorizing this transaction and naming who can sign. Council checks if these follow the rules and the statutes and the law quorum, voting, etc.
And if someone else signs using a power of attorney?
Then you need that power of attorney, the procuration. You review it carefully. Is it valid? Does it cover this transaction? Was the person granting it authorized to do so? The Civil Code has rules on this too.
Anything else? Notarial acts.
Yes, for certain company types like essays or specific actions like incorporation or major changes, you need the notarial act. The notary files these with the RCS.
What about lists of directors or owners?
An incumbency certificate listing current directors officers is helpful. And sometimes the register of shareholders or members is needed to understand ownership and control, which can tie into AMLUBO checks too. But the key is cross-verification. The RCS extract is just one piece. You need to check it against the underlying documents. Digital filing helps, but you still need to be sure about document validity.
It sounds like more than just reading documents.
Oh, it's active due diligence. You're scrutinizing everything for consistency, completeness, legal compliance. Does the board resolution match the powers in the statutes? Were quorum rules met? Does it match the RCS info?
What else does this diligence involve?
Checking execution formalities. Will the documents be signed correctly under Luxembourg law and the articles? Running up-to-date RCS searches, maybe litigation checks. Understanding the actual transaction is key. And considering any extra rules for regulated entities, banks, funds, DORA or MiCAR firms, their governance needs might be stricter.
Like DORA impacting tech contracts?
Exactly. And even AML-CF checks, like identifying UBOs under CSSF guidance, while separate, can give context, especially with complex structures. It's all about corroboration, fitting the pieces together.
Right, piecing together that legal puzzle. Let's dissect the opinion document itself. What's the typical anatomy, clause by clause?
Okay. Capacity opinions are pretty formal, structured documents. The exact layout might vary a bit by firm or deal, but there's a common flow. And remember, the assumptions and qualifications aren't just fine print. They're critical for defining the scope and managing liability.
So what comes first? The intro.
Yes, the standard intro stuff. Date, who it's addressed to, details of the company being opined on, definitions of the transaction and the specific documents reviewed. And crucially, a statement limiting the opinion to Luxembourg law as it stands on that date, as applied by local courts. You even see templates suggested now, like in that MiCAR circular.
Okay, after the intro, what's next? Assumptions.
Exactly. Core assumptions. These are things the lawyers rely on without checking themselves. Assumptions of fact and law.
Like what, for example?
Common ones include signatures are genuine, original documents are authentic, copies conform to originals, factual info from the company is accurate, the company is solvent, other parties have capacity and authority, the deal is legal under any other relevant laws, no nasty surprises from non-Luxembourg law, and everyone's acting in good faith.
Standard groundwork. Then the main event, the actual opinions.
Right, the operative clauses.
Yeah.
This is the core legal analysis. You'll typically see statements confirming. Due incorporation existence, the company was properly set up and exists.
Yeah.
Corporate power and capacity. It has the legal power, capacité social le pouvoir, capacité juridique, to enter into this deal and perform its duties, considering its object social.
And the internal approval.
Yes. Due authorization, all necessary corporate actions were properly taken. Due execution, the documents were correctly signed by authorized people.
And the enforceability point.
Legal, valid, binding, and enforceable obligations. But as I said, this one is nearly always heavily qualified. It's often a focus of negotiation.
Okay, so let's talk about those qualifications, the yes, but part.
Precisely. These are customary qualifications and limitations. Standard ones cover things like bankruptcy or insolvency laws overriding contractual rights, general principles of equity, or Luxembourg public policy, order public, potentially limiting enforcement, time limits for claims, rules against penalties, or excessive interest.
What else gets excluded?
Opinions usually exclude purely factual matters, the company's solvency now or in the future, tax or accounting issues, and whether the company will actually meet its financial promises or covenants. They also state they don't cover future law changes or things like international sanctions.
And with EU rules like DORA or MiCAR.
While these might lead to more standardized clauses for regulated firms, the core opinion still rests on Luxembourg corporate law. It's a bit of a hybrid. You need to reflect both the national law and any overriding EU requirements.
This clause-by-clause view is really clear. Now, the practical side, negotiations, costs, timelines, what's the typical experience? And just a reminder, this is based on general market practice, right? Not specific official sources for these points.
Exactly. This is based on common experience in the market. So, negotiations, who's usually involved?
Legal teams on both sides, I assume? The company getting the opinion and the one receiving it?
Correct. Lawyers for the main parties drive it, with input from the company itself and the recipient.
And what are they typically negotiating?
Key points are often The scope of documents reviewed, the precise wording of assumptions, the strength and wording of the opinion clauses, especially enforceability, how broad the qualifications are, and exactly who can rely on the opinion.
Why the negotiation? Isn't it standard?
There are standard elements, but it's about balancing needs. The recipient wants maximum assurance. The opining law firm needs to give a reliable opinion they can stand behind within their expertise, managing their own risk. Complex deals mean more negotiation. Sticking points often include enforceability strength, specific qualifications like insolvency or public policy, assumptions about facts they can't independently verify, or coverage of specific regulations beyond core capacity.
Makes sense. What about costs? Who pays and what drives the price?
Usually the party whose capacity is being checked pays their lawyer's fees for drafting the opinion. Often they also agree to cover the recipient's legal costs for reviewing it.
And what makes it cost more or less?
Several things. Complexity of the company's structure, number of entities involved, complexity of the deal itself, volume of documents to review, how much negotiation is needed, lawyer seniority and expertise, how urgent it is, and even how well organized the company's records are.
So mostly lawyer time.
Primarily. Market competition plays a role, but for major deals, the quality and reliability of the opinion are usually paramount, not just the fee.
And timelines. These opinions are often needed before a deal closes, right?
Yes, often a condition precedent, so the timeline is critical. Transaction lawyers usually manage this, sometimes with project managers.
How long does it generally take?
It varies hugely. Could be a few days for a simple, well-documented case. Could be several weeks for complex deals or if records need fixing first.
What are the main things that influence the timing?
Key dependencies include getting all the necessary documents quickly and completely from the client, how responsive the company is, time needed for internal approvals like board meetings, the complexity of negotiations, and any delays in RCS filings or updates. Since the opinion is often on the critical path to closing, there's usually pressure. Unforeseen regulatory changes or new legal issues can also cause delays.
Keeping up with those changes seems vital. What are some key recent or upcoming developments impacting these opinions?
Absolutely. The landscape keeps shifting, especially with EU initiatives. DORA, the Digital Operational Resilience Act, is a big one.
How does DORA affect capacity opinions? It's about IT risk.
Right. It applies from January 2025 to CSSF-supervised financial entities. While it doesn't change basic corporate capacity law, it mandates strong internal governance for ICT risk. So when these firms sign ICT contracts, their internal authorizations, the board resolutions, likely need to show they consider DORA requirements.
So it strengthens the due authorization aspect for those deals.
Exactly. Lawyers might need comfort that the approval process reflects DORA awareness. Major DORA governance failures could even attract regulatory action impacting the ability to transact. CSSF Circular 25883 also clarifies how DORA interacts with existing outsourcing rules, adding context.
What about the regulators' view on opinions generally? You mentioned MiCAR.
Yes, regulators are increasingly referencing or mandating opinions. The MiCAR example via CSSF Circular 25890 is key. It requires issuers of certain crypto assets to get a legal opinion for the CSSF, confirming the asset's legal classification, basically, that it isn't something else like a financial instrument or e-money.
So a direct regulatory requirement for an opinion.
Correct. And the fact that the CSSF adopted specific guidelines for content and form shows they want consistency and quality. This focus on asset classification is also interesting. It's broader than just the company's capacity to act. It suggests opinions are being used more widely for regulatory risk management. We saw something similar with STS securitizations, too.
And AML-CFT rules, how do they intersect, like UBO verification and CSSF Circular 19732?
AML-CFT is separate from capacity assessment, but it's relevant contextually. Understanding the ultimate beneficial ownership, especially in complex structures, can help assess the legitimacy of corporate authorizations. Rigorous UBO checks required by the CSSF circulars can indirectly support the capacity due diligence.
And significant AML failures could impact a firm's ability to transact.
Potentially, yes, through sanctions or restrictions, even if formal capacity isn't challenged. It's a related business risk. The principles of verifying counterparties also echo in rules like the travel rule for fund and crypto transfers.
With all this change, transaction documents must be evolving too.
Inevitably, new regulations mean required or implied updates to contracts. DORA, for instance, means ICT agreements need clauses on risk management, audit rights, security, incident reporting, exit plans.
What about MiCAR?
Agreements involving crypto need to reflect asset classification, maybe MiCAR compliance warranties backed by opinions. Custody deals need to be MiCAR compliant.
Any other examples?
Sure. The SEPA Instant Payments Regulation means updating payment clauses in loans, cash management deals. The European Green Bond Standard imposes specific disclosure and use of proceeds rules for UGB-labeled bonds. Even CSRD indirectly drives demand for sustainability-linked loans with specific terms and reporting.
So it's a ripple effect through the documentation.
Exactly. Regulatory changes cascade down, requiring contractual tweaks for compliance and risk allocation. Legal precedents need constant refreshing.
Which specific documents are most affected?
It's broad. For DORA, ICT service agreements, outsourcing deals, cloud contracts, software licenses, DPAs, business continuity plans. For MiCAR, crypto, purchase agreements, custody agreements, service provider terms, white papers. For SEPA instance, loan agreements, cash management deals, PSP terms. For green bonds, prospectuses, T&Cs, use of proceeds frameworks. For CSRD, indirectly, sustainability-linked loans, green loans, underwriting agreements.
And even internal documents.
Yes. Internal procedure manuals, risk policies, board resolution templates might need updates to reflect new considerations, like DORA checks for ICT contracts. Everything's interconnected. A change in operational resilience might make you rethink force majeure clauses elsewhere.
This has been incredibly insightful, a really thorough exploration. To wrap up, what are the main takeaways for our listeners?
I'd say 3 things. 1, capacity legal opinions are absolutely fundamental for legal certainty and risk management in Luxembourg finance. They depend on careful review within the civil code and company law framework.
Okay.
2, new EU rules like DORA and MiCAR, while not changing core capacity law, add new layers of obligation that shape due diligence, authorizations, and ultimately the opinions and documents themselves.
And the third?
Stay informed. Always use up-to-date official sources, Legalux, CSSF, and rely on expert legal counsel for specific advice in this complex and evolving area.
Excellent summary. Thanks so much for breaking all that down for us. Really valuable.
Pleasure to discuss it.
A reminder, this podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that you verify the information independently and consult with qualified professionals for personalized advice. Please do hit that like and subscribe button. This has been the Luxembourg Fundcast for you today.